Please, Your Lordship.
Yes.
If I may crave Your Lordship's indulgence to make a mention for moving a matter, my lords, tomorrow. There's an urgent matter, my lords, a quashing matter, where a 4-year-old case is sought to be revived by issuing a notice under Section 41, my lords, by the police. And that also purely in respect of a civil offence. The petitioners have been directed to appear before the police day after tomorrow, and they are from Bangalore, my lords.
A 4-year-old case cannot be investigated.
Well, look, investigation is there, but my lords, all of a sudden requiring us to appear in 2 days' time, my lords. That's the difference.
We'll have
Tomorrow.
Highly obliged.
Please, Your Lordships, item number 12, my lord. Item number 12, hearing list. It may be taken next week, my lord.
Who's the other side?
Other side is Madam Sharon is there. I already informed.
After?
Next week, my lord.
Next week. Okay, after
After the week.
after 1 week.
Okay.
After 1 week. Okay.
Evening.
Request please by learning Mr. Hajar ka learning counsel for the petitioner. List after 1 week. Yes.
No, sir.
Lordship, I beg to mention item number 10, Lordship. Lordship, I'm praying 2 weeks' time, Lordship, in this matter.
I'm for the respondent, Your Lordship. Actually, Your Lordship, in this criminal petition, they were supposed to provide, actually, in their petition, they have not annexed all the deposition of the witnesses, Your Lordship. So they were supposed to provide us.
So that has not been provided.
That has not been provided, Your
Okay,
Lordship.
that will be provided before the matter is taken up for hearing. There is an order to do that.
No,
To
because
supply
last,
copies and all.
no.
Is there any order passed by this court to
No, Your Lordship, because
incorporate those?
last time this matter was heard for some length. So at that time, the court observed that they have to supply, they have to bring it on record.
No order was passed.
No order was passed.
Then we'll see when it comes. Say this is
After
also
2 weeks,
prayer
Lordship.
made by the learned counsel of the petition. Just after 2 weeks. Yes.
Obliged.
Much obliged, Your Lordship.
May it please Your Lordship. I beg to mention item number 6.
Yes.
I'm for the petitioner. I don't have any objection.
When do you want it?
After 2 weeks, madam.
Okay. This is also this on request made by the learned counsel or the respondent, not objected by the counsel appearing for the petition. Just after 2 weeks. Yes.
Much obliged.
Your Lordship, objecting to item number 13.
Yes.
Yes, yeah, my senior is indisposed, Your Honor, so kindly.
Objection.
When do you want it?
After 3 weeks. Your Honor, in this case, we also have interim stay in the miss case, number 25.
Okay. On prayer made by the learned counsel for the petitioner, not objected to by the learned counsel appearing with the respondents, and the matter stands adjourned for 3 weeks. Stop the interim order, if any, shall continue till the next date. Yes.
May it please Your Lordship, I'd like to mention item number 8.
Yes.
Item 8 is the
Item number 8.
8, Your Lordship.
Yes.
I'm paying for respondents 3 and 4.
Who is the petitioner here? Yes.
Yeah.
No objection.
No objection. Okay. Just on prayer made on behalf of the respondent number.
3 and 4.
When do you want it?
2 weeks, Your Lordship.
Same order like this. Yes.
Your Lordship, joint request for item number 5, Your Lordship. I'm paying for the petitioner.
I'm from respondent 1 and 2, Your Lordship. It's a joint request, Your Lordship.
This is what the recruitment matter.
Yes,
is.
Your Lordship.
Okay. On joint request made by the parties. When?
2 weeks, Your Lordship.
Just after 2 weeks.
They're blessed.
Yes.
Thank you, Your Lordship.
Your Lordship, my apologies. Your Lordship, for item number 10, there was an order, Your Lordship, 3rd April 2025.
So we'll just see it. There is no problem. They will supply you before the hearing is taken up.
Yes, Lordship.
If they do not supply, we will not take up the hearing.
Because they had made a submission that it will be filed during the course of the day, Your Lordship, that's why.
That time we have already
They have
filed.
not filed.
They have not
Okay,
We
we'll
have
see the
filed the
content.
deposition of our petition, Lordship.
No, but then if you say that on during the course of the day, if it is submission, then you have to.
We have filed that, Lordship, the deposition.
We have filed already.
Yes, Lordship.
They have
Anyway,
not supplied us.
anyway, just provide them a copy.
Okay, Lordship.
Yes.
Major.
Obliged.
Yes.
Your Lordship, my apologies. Item number 13, there's no stay. There's a stay in item number 2, Your Lordship. So,
That item 13, do not give that. Yes.
Lordship, I make to mention item 5,
Item?
item 4, Lordship.
Item 4.
Yes, Lordship.
What happened to item 4? Revision application.
Yes, Lordship.
Yes.
I'm from petitioner, Lordship. Bring some 2 weeks time.
What order is sought to be revised here?
Lordship, it's against
Order passed by
by the district council, Lordship. Court.
District Council.
Yes, Lordship. Against the petitioner, Lordship.
In what matter? Title dispute.
Title dispute, Your Lordship.
Yes, the title suit, Lordship.
Title dispute, Your Lordship.
It's a joint prayer.
Lordship, I don't have any objection.
You do not have objection.
No, I don't have an objection, Your Lordship.
Just a prayer made by the petitioner, not objected to by the council for the respondents. After?
2 weeks.
Just after 2 weeks. Yes.
Much obliged, Lordship.
Item number 1.
Yes.
May please, Your Lordship. Lordship, the private respondent had sought time for filing their.
Yes. Respondent number 3.
Lordship,
Objection.
we'll
What
file
happened to
during
you?
the course of the day, Lordship. We'll file during the course of the day, Lordship.
So when shall we get listed?
After 2 weeks, Lordship.
Yes. Yes. Learned Council appealing for the respondent number 3 submits that the objection on behalf of the said respondent will be filed during the course of the day. So, do you have the submission? This is matter after 2 weeks.
2 weeks.
Obliged.
You are there for?
I'm for the state, Lordship.
So state is a party here.
Yes, 1 and 2.
Lordship, in the meantime, I may be allowed to file the rejoinder to their affidavits.
This is again revision. What rejoinder is needed? This is not like a writ petition. You see, rejoinder
Lordship,
is
but-
never a right.
Lordship, there
Let
are
us see.
certain
Let us
chief.
see what comes in the objection.
Yes,
We will
sir.
see.
Massive.
DPO.
Item number 2.
Yes.
Performer respondent, I'm entering appearance, my lord.
You will be contesting.
My lord, I am just a performer respondent.
So you will remain pro forma.
I'll
You will
remain
not be converted into contesting.
No, my lord.
Who is the contesting respondent?
I'll be filing my objection.
Okay. Mr.
Lordship, in the meantime, the interim stay will continue.
Wait.
in this case.
Mr. KCH Gautam, Learned Council has entered appearance on behalf of the performer respondent number.
2, my lord.
There is only one performer.
Well performer, my lord. Respondent.
Performer respondent number 2. Stop. Mr. R. Kharkan, Learned Council appearing for the respondent number 1. Praise for and granted. Praise for grant of some more time for filing an objection in the matter. Prayer allowed. List after 2 weeks.
Your Lordship, the interim stay.
But then there is
Miss case is there, Your Lordship.
no, that was not, they are not extended on the last occasion.
It's extended, Your Lordship.
No, there is no interim order. Where is it?
It says
Where is the order?
Order 0605/2025.
0605.
2025.
Where is the order? 0605. 0605. Where is the interim order? There is no interim order.
The first interim order is on the 11, Your Lordship. 11/04. In the miss case, Your Lordship. Miss case 25.
Just in the miscase, you just say, release this matter after 2 weeks. Interim order passed earlier shall continue till the next day.
Obliged.
Item number 3. 7.
May I please, Your Lordship?
Just a minute. Yes.
I pray that this matter be taken up after 1 week, Your Lordship.
Why after 1 week?
Learned Senior Counsel is like before the court number 2, Your Lordship.
But then for that you do not need 1 week time, do you? He will be not on legs for 1 week continuously. Will he be? Yes.
No objection, Lordship.
No objection. Possible after 1 week. Guest meet on behalf of the learned senior counsel appearing for the petitioner and not objected to by learned counsel appearing for the respondents. List this matter after a week. Yes.
Much a pleasure, Lordship.
Item number 9.
Maybe Lordship.
Yes.
I am the poor petitioner, Your Lordship, actually. This is I'm challenging the imperial order.
Production of records.
Directed to produce the record. The record is there with me, my lord.
You have
Yes, I have.
gone through the thing. You have gone through the records and
Entire record I could not go through, my lord, but
the relevant parts.
the
What is
relevant
the
parts I have gone through.
what is the grounds raised here? What is the grounds on which Mr. Sangma?
Yes, actually here
what is
only
the
because
principal
of
ground?
the this condemnation they have condemned Delhi, but the problem the ground is that the person who filed the condemnation of Delhi before the CM of GHTC is nobody. He is not even a NOCMA. He has no locality to file the application for condemnation, seeking a condemnation of Delhi. That is because he claimed himself that he is the private respondent. He claimed that he is a NOCMA, but
So
he is
you
not.
agree
He is not a
by-
NOCMA. I have enclosed that earlier they were fighting for NOCMA among themselves. The repetition is clearly.
Just go slow, go slow.
Lordship.
Go slow. Now you have to give us the background. Who are you?
No,
What is your background?
no, I am NOCMA of one particular Dari Bokri.
So you are NOCMA of
Dari
which
Bokri.
area?
That is called Dari Bokri. Name of that place is Dari Bokri.
What is the cause of action in this writ petition? What for?
Yes,
You have
course.
challenged what here? What is the order here?
His Lordship. I have challenged this order to set aside this Lordship.
What is the order? Which is the order
That
which is under challenge?
That is
Order passed by the
yes.
EM.
Yes, order 15
EM or CM?
CEM 15 15/11/2022. That is an
What-
annexure.
What is the page?
This one. This is annexure 10.
Yes.
Annexure 10, page 65.
Yes.
This is judgment. I'm gripped by this order. It is passed by the chief executive member of Garhwes Autonomous District Council, Tura. So this is very long order, Your Lordship. May I read it, Your Lordship?
Now, in the ex parte order passed in your favor by the EM,
Yes, Lordship.
who were the respondents?
They are the respondents.
Yes,
Yes.
the
The respondents.
So it is not a case that that was a third party appeal preferred before the CEM.
Yes. But
They were a party. To
they were
this.
party. They were party.
But they challenged the ex parte order.
Yes. The
They
challenge.
preferred the appeal after the expiry of the limitation period.
Yes,
And they filed an application under section 5 of the limitation.
Lordship.
And then you are challenging this on what ground?
Yes, challenging because that person who has filed actually was arrayed as a party, but prior to passing of the order, EM has issued a notice to even to these people.
It's okay, they did not.
They were participant.
Anyway, let us assume
Yes.
that he was at fault.
Yes.
Okay.
Later on he
So
did.
now, what is your ground for challenge so far as this condemnation application is concerned?
Now the ground is actually one aspect is Lordship that person who has filed his continuation of delay, of course, he was arraigned as a party
Yes.
in the court of EM and the CM. But he is nobody. He is not even the Nokma of that.
But then you have made him a party.
No, Nokma, no, the real Nokma.
Doesn't matter whether it's a NECMA or not. You have made him a party. We will not see he is a party. It is not a case that a stranger came and he filed appeal, isn't it?
Yes.
You have made him a party. You issued him notice. He received the notice. He did not come.
We did not issue the
he did not come. He did not bother to appear.
Yes, he did
Okay,
not
so
bother.
EM passes order against him,
Yes.
and he prefers an ex parte appeal.
Yes.
How can you say that he is nobody?
Nobody
If he
in
is
the
nobody,
sense.
then why you have made him a party?
No, it is the party is made by the JHTC, not by the private respondent. You will come to the
Party is not. Then who filed the proceeding before the executive? Was it a Suamotor proceeding?
this. May I take it to annexure 5.
Just tell us the facts. Why you would just take us to the first? Let us understand. We'll just see whether there is any ground for going into the
Your
merits.
Lordship, petition was filed by us, filed by the petitioner.
So
Then
that your argument that he is nobody, we will not accept it. We reject it. Outrightly reject it. What else? What second ground do you have?
then the Lordship that there is no proper explanation because there are 3,000.
You will not say about
500
the application of Limitation Act.
Actually, another ground is that 5,090 days, the application filed before the CEM that they have not given there was
Mr.
no
Paul,
even the proper
Tell us
explanation.
one thing. If petition is argued by not raising a point, now court finds that that may be a good
Relevant consideration.
Now, whether that can be utilized, that point, that ground can be used for passing the judgment, can be taken into consideration without affording a chance to the other side to argue on that point. Now, it may happen, Mr. Sangma completes his argument
Without raising that issue.
without raise it, a point. Later on, the court finds that he left out some vital point. And court finds that maybe a good point for interference. Court passes an order interfering. But then the fact would remain that the same point was not argued and the other side did not
That
raise
was
it.
not.
So will it invite illegality if it is done?
It's in all fairness, no. It's an application of law. We are here to assist my lords in deciding a matter, my lords, and any applicable law, my lords, even if it is not argued by both the sides, if my lords find that there is an issue of law, matter can be decided, my lords.
But then if that issue is not raised, not argued,
I'll have to go back to
court-
that
court-
Latin maxim, ignorantia juris non excusat.
but
Whatever
then
we
is
know, my
it,
lords,
is it not that this, if any point is raised or the ground on which order is interfered with, the aggrieved party must get some chance to place his position.
lordships. My lords may then, my lords, put this query to both the parties, my lords, that
No, we do not want to make it complicated. But then I'm just probably just after going through the petition
my lords,
suddenly.
in all fairness, my lords, have submitted. In fairness, my lords, that would
No,
be
that
an issue,
is
but
definitely that is expected. You are senior counsel. That is expected of you. The court is asking for assistance.
my lords, in all fairness, my lords, that my in my humble submission, my lords, may not be
Yes.
per se illegality committed by.
So anyway,
If your lordships will decide the dispute within the parameters of law, whichever they are applicable, even if both the parties have not placed a certain aspect of law, my lords are better equipped with the law, my lords, to decide the matter.
see, his entire grievance seems to be against
The condemnation.
condemnation. Now, we do not know the ground which is raising about that your locus standi that he is
merits
nobody
of the matter.
would not stand because he himself has made him a party to these things. We are not going to any other thing. That is good enough. But then the other grounds which Mr. Sangma has not raised. Now, it may become
That becomes a. It's my Achilles' heel, my lords, I must concede. If I may, my lords, there can be a via media. From whatever has fallen from my lords, as what my learned friend's case is also. Only the issue of delay has been decided, my lords. The merits have not been decided by the CM. Whatever his grievances, my lords, the entire matter, along with all related issues, can be decided by the CM.
You can understand that. But then the thing is that whether the Section 5 limitation act would apply.
Does not apply.
If it doesn't apply, then the authority cannot have any inherent power to condone.
Condone the delay. He has to act within the four corners of the statute.
So that is what will be the problem then. Then it will be an illegal exercise of jurisdiction. And this court will have to interfere, will not have.
Logic. I bow down to that because I was just telling my friend here for the district council that this is a difficulty that we'll have in this matter. But be that as it may, I don't think the petitioner per se is urging that issue before your lordships regarding the jurisdiction of the council.
Now what happens is, supposing in such matters where the prescribed period within such an appeal should be filed is not filed, then what remedy is available to the aggrieved party?
It's before the competent authority, whichever authority the limitation is prescribed, he will be bound by that because he will not have any inherent powers as your lordships.
So what remedy would open?
He'd have to then come before a superior court, to get some kind of remedy. My lords would then have to balance the equities, and
The problem is that while balancing the equity, you cannot uphold a decision which apparently is passed illegally.
patently
So that is what the problem is.
this would go to
Even
the very...
if we understand that that you must have a right to appeal, but for that we cannot uphold a decision which admittedly is passed by resorting a jurisdiction which was not vested.
vested in. This would be a case of exercise of jurisdiction in excess of jurisdiction vested in law. Because his powers
So
of
if it
appeal
goes,
would
then
only
where
be
you will
within the
stand?
limited period.
If it goes, then where you will stand? Then your opportunity. What is about your opportunity of filing appeal? Then
I would have to come before an appropriate forum. Which is why I say, that there will have to be some balance of equities.
No, but then in such a case, then you have to think about your own.
That
Really?
puts me in a...
We cannot do anything here, even if we feel that we should do something.
It's a peculiar circumstances of this matter,
Which are there is nothing for you to defend here.
My lord, there is nothing for me to defend,
View
but,
of,
but
the very fair submission made by Mr.
My lord, my
nothing
lord.
remains for you.
My lord, just totally, I have no dispute on
Of course,
that.
this
my lord.
court appreciates that, you see, like.
Yes.
And
Only
I
thing
believe-
is this, my lord.
yes.
In many occasions, my lord, we have find there is an order of this honorable court, not this court, my lord, but other courts where they direct us to condone the delay, my lord. They direct us, my lord. Then we have no other option than to condone, my lord. And Mr. Sangma was the beneficiary of that.
Any precedence? Can you show any order?
Yes, my lord. I will place it, my lord. I will.
There have been instances where my lords have
See,
indicated...
though, if you go by that ground, then Mr. Sangma has a good case.
Lordship.
But at the same time, we would not like to shut you down. At least it is only the order of EM. Should not achieve finality.
Merely
You
because...
must have some. But if you pass any order in his favor,
My lord,
allows
may
his
kindly
petition.
see- My lord, may kindly see also
Kindly,
the
kindly
application.
place before us that a read
My
court can grant that thing.
That has been given, my lord.
Then
Mr.
in
Sangma
such
was
a
the
case,
beneficiary.
We interfere, we will remand it back and tell this CEM to look into the matter of condemnation on the basis of fresh application filed by them.
But
If you
my
can
lord,
show
the
us some decisions. Otherwise,
application for delay of condemnation
yes,
has been filed, my lord.
That is
Explanation has been given.
that is okay. But then where is the power? We are talking about the application of Section 5 limitation.
Limitation Act per se will not apply.
I totally agree, my lord. There's no dispute about that, my lord. As I
very
submit
clear
in my
submission by
first
the
stand,
senior
my lord. Only thing is this, my lord, because there was a precedent, my lord, of this honorable court. I will please it, my lord.
Just show us.
will try and assist
Though
this
this court
honourable
has,
court on this issue.
though this court has a doubt, let us see what kind of order is passed.
My lord, my lord.
Please assist us if you can do
Well,
something.
My lord. Let's
Also,
come
my
up
lords,
next
on the issue of, in these cases, my lords, what would be the way out? We'll try and do some research and get back to my lords. It puts us in a very precarious kind of a situation, my lords, as your lordships have rightly pointed out.
That is why legal matters need to be handled by right person. Sometimes the role of a lawyer in giving relief to his client worsens the situation. Yes, Mr. Sangma, your submission is not accepted. Your case will be rejected. You have not raised any point. The point, if that is your only point, what other ground you have?
I'll prepare, lordship, the next day.
But then you were prepared to argue the matter.
Next-
You started the thing, argument.
I will place those orders, my lord.
Place it, but then-
I remember it correctly, my lord. 2 orders are there, where delay of condemnation court has directed to the petitioner, my lord.
At least
to
we need
approach.
some principle basic on which we can pass it.
For the end of justice, those kind of order was
But
passed.
then if a power is not conferred by the statute, can the writ court confer that power? That is also a question.
Keeping in
We do not
mind-
just try to find out some way
Again,
out.
if we go back, this is on a broader parameter. As your lordships are aware, there's a principle which operates that an inferior court, my lords, can only operate within the four corners of the statute, not my lords. The term used by the lordships, my lords, of the Supreme Court, I'm not going into that. And they say, my lords, the superior court, everything is within the jurisdiction of a superior court or a constitutional court, even if it is not provided under the statute to secure the ends of justice. If for larger issues, my lords, of equities between the parties, your lordships find that this is a necessary issue, my lords, your lordships.
See,
I'll
we
place
could
that.
have done it had there been approach by you against the order of him. When you find that this order is time barred, if you had approached the writ court, maybe writ court could have condoned the delay and directed the without conferring that power to condone.
Lordships.
Without conferring
Your
the power
lordships
to
would
the
have
CM.
condoned the delay and
could
say
have-
that
maybe
decide
in
your
writ court for ends of justice we can.
My lords.
But then here the situation is different.
Which I said, that particular court, my lord, had to act within the four corners of the statute. It could not have gone.
Just see one thing. Mr. Day said that he will.
I'll
show
place,
his order,
I'll place.
where direction is passed to the.
To condone the delay and then
Condone
proceed
delay.
with it.
But then what you submit that appears to be more attractive in the case that before remanding we condone the delay.
That
That
be
would
the
have been a
thing.
right.
Now at least give us something that we can do it.
No, in these-
Where you are responded.
No, my lords, in these peculiar facts, where the delay has been condoned, but the petitioner per se is not challenging the application of the Limitation Act. my lords. That's also not the
That is what we say.
But we are faced with a situation, my lords, I
The
must
very
concede that's
purpose
the
of
law.
asking the first question was that because this court realized that Mr. Sangma is not.
Raise that issue.
Yes.
However, my lord, since that operates in the field, your lordships would have to then decide on this issue. Which is why I say, my lords, we'll try and assist your lordships.
Yes, what is to be done? We'll dismiss your case now. You have not raised any acceptable point, at least.
Come after 2 weeks, my lord. I'll give assistance.
When shall we have it?
It is convenient to your lordship, my lords. We'll try and take it. It can be next week, my lords, because then it'll be fresh in our minds.
So okay, next week we do not know if we are not already. Next week will be all right, or
22 cases.
oh, I think after 2 weeks is better. On your prayer. Yes, on request made by Mr. P.T. Sangma, London Council, applying for the petition. This is matter after 2 weeks.
I'll leave it.
What's press lordship?
Item number 11.
Please, Your Lordship, I pray that this matter will be taken after 2 weeks, Your Lordship.
Why?
Because the conducting council is on sanction leave,
there?
Your Lordship. Your Lordship, I was instructed to take
You argue very well. What is the problem?
but I was instructed, Your Lordship, to.
What is the matter about here?
My lords, they had made a request for adding some additional issues in the course of the trial that was rejected by the learned trial court.
It's a framing of some additional issues.
Framing of additional issues. They're actually very vague, the issues. That we'll just see what the issues are. I'll just point out. If your lordships have page 27 of the revision application. At page 27,
Yes.
para 23.
Yes.
Whether the suit is maintainable under law and fact.
Yes. That is a general.
It's a general one, my lord.
Yes.
So for that, there is no necessity to file a 227 and stall the trial. And whether the suit is maintainable under the Meghalaya Land and Revenue Regulation as well as under the specific
This will
relief.
come under the first one, first clause.
My lord, exactly.
No, but then whether this issue of maintainability is not framed.
It wasn't framed earlier. My lords, I have no difficulty even if it is allowed. The problem with this
So we'll
revision
allow
is
this
this is
petition?
yes, my lord. As far as one is concerned, one will subsume number 2 as well. One is more than enough.
Okay, then
Whether
we'll
the
just
suit is
record
maintainable.
that you
Yes,
concede and then that is instead
There
of.
is no necessity for any
Yes.
further hearing.
Yes, we'll dispose it of then.
Okay.
Yes.
Because the suit is from 1997.
Yes, just say hard, Mr. Neuter, learned counsel, appearing for the petitioner, and also Mr. S. and learned counsel appearing for the. How many respondents are there?
Sole respondent.
Appearing for the sole respondents.
Well, may I just make a small submission, my lords? I'm not going into the merit of this case.
Yes, yes.
Just with the intention of ensuring that the case proceeds quickly.
We'll say that since Mr. Sen has not objected to the grant of the prayer,
With regard to number one, my lord.
without
Issue number
reference to the merit of the case, we'll just.
Lordship.
Yes. Just see, just court is passing order. If anything is needed to be corrected, just point it out.
Yes, my lord.
Sit down, you can sit down. Okay. Being aggrieved by the order dated 29/10/2024, passed in Miss Case number 13 of 2024, arising out of title suit number 4 of 1997 by the Court of the Assistant Deputy Commissioner within bracket J, South Garo Hills, Empathy, the petitioner has preferred this application before this court. Praying for a direction framing of paper direction to the trial court for framing of two additional issues. Which are as follows. Already six issues are framed. 7 issues are framed. Okay, what we said? Just line. From original issues. Praying for framing of 2 additional issues. As which are as follows. These are numbered here as issue number 8 and 9. Shall we go by the same? In the petition at para 6,
Yes, my lord.
page 5, they have numbered it as issue number 8 and 9.
Adding to the original one.
Yes, sir.
That is
Okay. So that is why this court is a bit confused.
why. This is what they are suggesting should be framed by the court. The additional issues.
Yes. So you do not have objection to that, isn't it?
Yes. As far as 8, my lord. 8 and 9 are pretty much the same.
So that is same. It will cover the 9, but then
Yes.
well, no problem. The trial court will
Only in the
answer.
interest of early disposal of the suit, my lord.
Okay. As the which are as no, just a minute, for additional issues as issue number 8 and 9, which are as follows. Okay. Then you give number 8 and number 9 and see paragraph 6 at page 5 of the petition. Only these 2 issues. Other contents of the paragraph is not needed. Okay. Mr. Shen, the paragraph. Mr. Shen, learned counsel for the respondent at the very outset. submitted that he has no objection to the prayer of framing of additional issues made by the petitioner. Stop. He submits it. The additional issues suggested by the petitioners are formal in nature and would not prejudice the respondent.
And just one more thing. If your lordship see page 28, the court has partially allowed one of the issues to be framed at para 33. Therefore, I was saying that one of the issues is fine. At para 33, we'll find whether the suit land is maintainable under Meghalaya Land and Revenue Regulation Act. This has been framed by the court already, partially framed.
See, if it is this the additional issue is also framed, this will basically it will merge with that thing when its answer is.
Lordship. No, just for your
Because
lordship's
it will
information.
everything will come under one umbrella.
Yes, yes, absolutely.
Okay. What you say? Just sir. What we said are suggested by the petitioners. In view of the issue number, what is that other issue which was framed?
Well, the issue that was framed is that issue number, the second issue, whether the suit is maintainable under Meghalaya Land and Revenue Regulation.
We have the issue number 2, which has already been framed by the.
Partially, well, they've left out the mention of specific relief act.
Where is the picture?
So, my lords will find at page 27, that is the impugned note at page 27.
Yes.
At para 23.
Page 27.
Page 27.
Is there any? Yes.
Please see para 23. These are the two issues that were proposed by the petitioner herein. The second issue, my lords, is whether the suit is maintainable under the Meghalaya Land and Revenue Regulation as well as under the Specific Relief Act.
Yes.
At para 33 in the next page. Para 33 next page, my lord will see, in view of the above discussion, proposed additional issue number 2 is partially allowed to add whether the suit land is maintainable under Meghalaya Land and Revenue Regulation
That is
Act.
okay. What we are saying, we are just recording your submission.
Yes, ma'am.
Saying that in view of the framing of the issue, these are all formal.
Yes, my lord.
So that is what we are saying. What we said, Mr. Soizer? In view of the issue number 2, which was been modified by the trial court as, then you get it at page 28, para 35, written in bold letter. Just see, just you look. Okay, then come next paragraph. Just say, in view of the submission made by the learned counsel for the respondent, this application is disposed of with a direction to the trial court to incorporate the additional issues suggested by the petitioner as issue number 8 and 9. What is it? Incorporate, you just say add. Just you say in view of the nationwide thing, oh, incorporate, acha. 8 and 9. Anything more is needed? Nothing? Yes. And before proceeding further with the trial, That will
In the
alright?
course of the trial, they can frame because parties are aware.
Yes.
What is their case will be based on the issues framed. They're otherwise aware. It won't be fatal, my lords, because lordships are aware. Even before rendering judgment, the court can frame an issue if it comes to the court from the materials on record. So, if lordships passes order now, on the next very sitting of the court may frame these two issues, may add these two issues to the issues that have already been framed. That can be done.
No, we are just saying that it should be, let it be incorporated as additional issues. That is all. Stop. Is without just see stop. It is made clear that the order has been passed on the basis of concession made by the learned counsel for the petitioner, without any reference to the merit of the case.
Oh, respondent, my lord.
Merit
Concession
counsel for
of
the
the
respondent without any reference to the
merits.
merits of the case. Stop. And last time, the petition stands disposed of in the first terms. There may be correction of words and all
Yes,
here,
ma'am.
there. Yes. Small matters can be disposed of when you see the other side is ready to give you relief. Yes, nothing more.
Congratulations.
Right.